Benjamin Mak, principal and patent attorney at Smart & Bigger. Many artificial intelligence AI companies can generate complex technologies that are confusing for others to understand. Benjamin assists AI companies in building their patent strategy that clearly tells the story of the invention to their stakeholders and to the patent offices. So with that, and without further ado, Ben, if you want to start sharing your screen. You are. Excellent. Take it away.
All right. Thanks, Earl. Hopefully everyone can hear me. So I will today talk about software patents and more particularly AI patents. In the past, we have spoken about patentability of AI and software. So this is more about updates, but there is sort of a rich history of software patents at the US Patent Office. So today in our 20 minutes, we can only talk about the updates, but I'm happy to chat offline about the general tests. So this is just sort of what's happened in the last few months, in fact, as recently as August. So since this is a good year in review. Okay, so there we go. This is my firm. It is Smart & Bigger. That was actually the names of the lawyers at the time, and we're happy to help with full service IP and patent work. This is me. I am a lawyer and a patent agent. Okay, so today we'll talk about kind of four main things, but really focusing on the first two. So there's new guidelines on patents, patentability of AI. There was a recent decision regarding AI, and then there were two other updates, which we will talk about briefly, because one of them even, in fact, came out yesterday. But generally, for those who are a little lost, I'm talking about patents today. I'm not talking about SRED, although there may be some overlap in concepts and the idea of trying to bring some ideas and thoughts and abstract algorithms onto a computer. A lot of the challenges are similar, let's say. Okay, so new guidelines. New guidelines issued in August, which is fairly recently. It's an add-on to previous guidelines. We call 101 the same thing as these abstract guidelines. So really the question is your software, let's say, technical enough? And if it's technical enough, then it can go into the patent office and then do the remaining examinations, which is usually novelty and inventiveness and some other things. But 101, which is literally the first provision of the Patent Act in the US, just says it has to be an invention, it has to be a patentable method of some sort, a patentable process. So the question is whether that process is just a mental process or a technical process through your computer. Okay, so the memo came out, as it says this is not intended to introduce new practices, but it is a reminder to examiners, which is a sort of a code word, but as we can see, a lot of the language is pro-patent and pro-AI patent. And they did have a note on close calls, which is 50-50. And they say actually 50-50 goes to the patent applicant in terms of approving it, in terms of whether it's technical enough. We're not talking about obviousness today, other than if it goes into these considerations. Generally, we're just going to talk about, let's just say, is it technical enough? Is it not an abstract idea? Is it not a mental process? Is it not a mere algorithm? So some of these things are tests because, again, they are add-on, but on a very high level, if you want to assess whether something is patentable, has to be something, a process, a machine, a manufacture, and composition of matter. That's literally 101 of the US Patent Act, and the controversy is whether the process can be a computer implemented process or for the machine, whether the computer as a machine is patentable because it's programmed with sufficient technicality. Step 2 is then we look into, is the claim directed to one of the judicial exceptions, mostly being abstract idea. We can talk about law of nature and natural phenomenon later, but generally a lot of these coding concepts are abstract ideas that we're putting onto a computer. And then 2B is, does the claim recite additional elements that amount to significantly more than the recited judicial exception itself? So I don't want to belabor things too much because, again, we're not getting to the new part yet, but there is sort of this test of whether something is patentable. Step 1, it's a bit convoluted, but let's go through a little bit of it anyway. Step 1 is, again, is the claim invention fall into at least one of a process, a machine, a manufacture, or composition of matter. If it's not even pretending to be one of those categories, then it's not patentable. So let's just say it's yes. Let's go to step 2, which they've now broken up into 2 steps, 2A and 2B. 2A being whether it's a judicial exception. Usually it's abstract idea. So we're trying to put an abstract idea onto a computer. And if the answer is no, so we can pass that sometimes and go right to patentable subject matter. Then they have 2B, which is, does it result in something significantly more than that exception? And sometimes that's where we bring in some novelty and inventiveness into the exercise. And the courts have decided, let's split up step 2A even more and then say prong 1 is an abstract idea, but then does it recite additional elements that integrate the judicial exception into what we call a practical application now, which, again, practical application is tough, like things like fintech, purchasing stocks, crypto, like how practical do you need to be for practical application? There have been cases, I can't recall whether they've been overturned, but even like a garage door opener, which is clearly a practical application, had a lot of algorithm behind it, and then at the end you would open and close the door, and then that one was strangely disputed and went pretty high up. Last I checked, the answer was no. I just don't know if they appealed it, but a practical application is tough to define, but in theory, you can pass at prong 2, which is whether it's a practical application, and then it can still be saved by step 2B, the significantly more. And often the significantly more can't, it's hard to say, but sometimes it can't just be a human advantage or a human application, saying like, on your bank loan, what's your gender or your age, or, just things, what's the weather that day. So things that don't seem to be applicable to the technical solution. Rather, these seem to be more like human solutions. Okay, so what do they say? So mental processes are limitation, are okay. Well, it's mental if it could be performed by the human mind, okay? But we can't try to expand this definition too much. So they say it can't be practically be performed by the human mind. A really easy example is hardware-based RFID. That can't be done by the human mind. RFID being those short-range tapping your phone and security badges. That's what I mean by RFID. And that's the example they give. So obviously that is not a mental process. But when they talk about AI, they actually said we should look at that, and can that be done by the human mind practically? And they actually said, well, good for us, or for any patent owners, that a lot of AI and neural network training and things cannot be practically be performed by the human mind. Okay, so the judicial exception. So I'm going to read this example that they gave. Training the neural network in a first stage using the first training set. That is not a judicial exception, which means it is good. Let's just say that's yes, that's a yes. Strangely, they give another example, example 47, which is training by the computer, the artificial neural network based on the input data and a selected training algorithm to generate a trained ANN, wherein the selected training algorithm includes a backpropagation algorithm and a gradient descent algorithm. So the first mistake was they used the word algorithm, call it something else. And this is probably the first time I've ever seen this. This is a personal commentary that the narrower claim is not allowed, but the broader claim is allowed because it didn't specify an algorithm, and an algorithm is a judicial exception. So very odd result. It's in the guidelines. So I mean, a lot of best practices are just kind of follow the language that they are doing. But you're still going to need support in your specification and figures and description of what types of algorithms would make sense for your neural network to work. But they said, well, example 39 didn't actually specify a specific algorithm, and that's a good thing, apparently. Anyway, so we'll go with what they said. Obviously, we'll just use the language as stated when needed in the future. Okay, so that's an interesting conclusion. Another thing is which is a favorable note, is they say, hey, when looking at the claim, analyze the whole claim as a whole. A claim is not just one line or one word. It's a whole paragraph if you've seen them, or sometimes they're a page. Sometimes they could be pages. But look at the whole claim, which is kind of a good point of emphasis. You can't just look at one little bit and try to analyze that bit in a bubble. Look at the whole claim. So that's great. They just keep hammering in the positive elements of the law that are in the favor of patent owners. And then you consider the claim limitations and how they all interact with each other. Again, you can't just take one limitation in a bubble and do the analysis. And then you look at the whole claim, and then you say, does at 2A prong 2, does the claim integrate this sort of exception into a practical application? So now you can save by the practical application exception of the exception. And then if yes, you're good. And then no, you can be saved again later on. Okay, so improvements to the computer are good. That's usually how we try to frame it. It's tough when often AI is more accuracy, so trying to mimic human behavior and then be something more accurate. Let's just say a virtual therapist, something like that. So that, I can't say always, but often may be less considered to be important of accuracy or mimicking human behavior. It's like, how are we actually improving the computer? And then we consider the extent to which the claim covers that particular solution or method to achieve it. Is that improvement disclosed in the specification? But strangely, it says that the improvement to the computer doesn't have to be explicit. So let's just say we saved X amount of layers in our neural network, or less computation, which means less energy. Sometimes we can say it's less processing or better than whatever, rules-based, better than a fully connected neural network. Those are things that we try to focus upon. And they actually, again, this is very good language. We don't have to explicitly say it in the specification in the US. In other countries, it's probably good practice to do so. US, they say, well, would anyone have understood that using this algorithm would have improved the computer? Usually it's less processing, but it could be more efficiency to the answer, convergence to the answer quicker, rather than just saying it's more accurate for humans. Okay, so the apply consideration is usually it's a rejection. You can't just take a mere abstract algorithm and just say apply it on a computer. So I mean, that's still true. That's basically the definition of an abstract idea, that you are literally just saying, and then let's put it on a computer. But again, this is favorable. They said, let's avoid any oversimplification or expanding or summarizing. In other words, if the claim is a paragraph or multiple paragraphs long, you can't just paraphrase it into 3 words and say, we're doing a financial algorithm that's buy low, sell high. We can't just if it was a 3-page claim, we can't just simplify it into like 2 words and then say, let's put that on the computer and then reject the whole thing. So again, when the patent office is saying things like, let's avoid oversimplification, that's good for real tech owners who have done real technology. Also, obviously, there has to be an improvement. We can't do a mere algorithm that's already known and put that on a computer. So we have to figure out what was the actual algorithm that we're putting on the computer, and there will be some improvement in there, or else, why else would we be filing this patent? So of course, we're going to look for the newish part of the algorithm. Okay, and a similar note, you can't just say the computer is a mere tool, but it can be a tool. It just can't be merely a tool. So these are all positives in our favor. Okay, so for close calls, again, they've actually reiterated that you can only reject if it's more likely than not, this is a triple negative here, more likely than not that a claim is ineligible. In other words, it's, which is a strange burden, but we'll take it, that it's the examiner's burden. It's not us, it's not our burden to show patentability, it's the examiner's burden to show it's not patentable for this particular feature. And the examiner should not reject it because they are uncertain, of course. The burden appears to be on the US Patent Office to first prove ineligibility rather than the applicant to prove eligibility. Again, good news. And rejection must be established by preponderance of evidence. In other words, they can't just provide conclusions, which is what we often get, which again, they can't just paraphrase the claim into simplified form and then just say it's a computer. You have to actually flush out the whole argument, which is a lot of work for the examiner. And we're going to see something interesting later on that does seem to be a little more conclusion, again, in our favor, strangely. But again, you have to show evidence. You have to do the argument and analysis. You can't just say it. Say, oh, this looks like it's a mental idea. Okay, those are the new guidelines. Soon after the guidelines, there was a patent decision. So let's go through the case history first. So for patent office has to do an examination. That's the patent application number 040, owned by Google's DeepMind. Now, people are not supposed to look at the applicant, but I'm sure someone at some point looked at the applicant name, Google. And they had a method of training machine learning models on multiple tasks. Okay. It got rejected, so now we're up to the patent trial and appeal board stage, who affirmed the examiner's rejections. And then we're at the appeal review panel now, and that's what we're talking about today. Okay. So we're not at the federal court yet, we're at the appeal review panel of the patent office. So it is a transfer learning algorithm. The new USPTO director himself, John Squires, decided to just convene this panel, and he signed off on the decision himself, as well as 2 other very senior officers, acting commissioner of patents and vice chief administrative patent Judge Kim. And then vacated means vacated the rejection means they said it was patentable. Double negative there. So so what's happened? I don't want to get into the science, but if anyone knows anything about transfer learning, basically you might learn to do one task, but then you can apply those learnings to a second task. So for example, this is my example, not the case, but you teach a robot arm to catch a ball, and then you might teach that robot arm to drink a glass of water, and the arm has to go reach the thing and do this task. It's a second task, but there are learnings that were made from the first task. So I don't want to get into it too much, but there are a lot of positives. So it looks like it's interesting technology. Improvement of the machine learning model, not a mere algorithm. And then once this model has been trained, the model can be used for each of the further tasks within some acceptable level of performance because you learned from the first task. So we wanted to avoid this catastrophic forgetting of the model. So I'm just presuming everyone knows about machine learning at this point. So this is a rather long claim. We have materials later, but it's not too sciencey either. It's actually kind of broad, frankly. But we have a computer implemented method of training a machine learning model. For brevity, we don't have time to read the whole claim, but so I'll just go to the emphasized parts, which is computing an approximation of a posterior distribution over possible values of the plurality of parameters, and then adjust the first values, that's the first task, of the plurality of parameters to optimize performance of the machine learning model on the second machine learning task, while protecting performance of the machine learning model on the first task. So it learns something, you're not ruining the first task, but you're using those learnings. A lot of this is actually called transfer learning, but let's assume it's new. Maybe this is a really old patent. It was filed, it's filed 2017-ish. This is not that old. Provisional was filed 2016, so it's oldish. Okay, so transfer learning probably came around 2016, maybe a few years before then. So maybe this was a foundational patent, which is why they want to get a patent on it. And it was filed in 2016. So maybe my learnings of transfer learning came from this board research. Okay, so back to the tests and the prongs. So they did agree with the examiner that this was an abstract idea. It's some sort of math. They said, yes, this is an abstract idea. But then on step 2A, prong 2, the appeal board held that the claims sufficiently reflect improvement on how the ML model operates. And specifically, they identified some improvements, which again don't have to be in the description, and effectively learning new tasks in succession whilst protecting knowledge about previous tasks, using less of their storage capacity and enabling reduced system complexity. I have a feeling they didn't write these in the spec. I do have this. We have the spec in materials if anyone wants to verify, but I think these were just post arguments that they did to try to get the patent through. But in the new guidelines, you don't have to actually explicitly say all the advantages and why it improves the computer. Okay, so here's this part of the claim did reflect the improvement. I did read it earlier, but it is adjusting the first values for the first task, for the second task, while protecting the first task. So the panel did essentially equate any machine learning to an algorithm with generic computer components. So that was the examiner. They said, well, you can't just say everything is a generic algorithm. So that's too high of a level of generality. Okay. They also said they criticized the panel for being overbroad. Again, this is good language for good ammunition for us. You can't say it's overbroad, overbroad reasoning, and it seems to be just categorically excluding AI innovation, which, as we all know, will be the frontier for the next 10 to 100 years. So they can't just say it's all abstract because it's AI. And finally, on a personal note, 102, 103, and 112, like that's just like novelty, inventiveness, clarity. Like these are things that we should be focusing on, not 101, which is literally the first provision of the Patent Act, which just says, is this a method? We should focus on 102, 103, which is novelty, inventiveness, or obviousness, and 112, which is clarity. So let's focus on the real heart of the invention and not invalidating and disputing everything on 101, which is whether it's a suitable method for examination. And this is actually a long time coming that they would say this. Okay, so this was a reversal, first reversal, SME subject matter eligibility. This is a shift of how AI-related claims are analyzed. The USPTO has to show ineligibility. ML, obviously improving the model is good. And then he seems to have a pro-patent stance. Okay, that's topic 2. Topic 3 is really quick. As of yesterday, there's a new memo from Commissioner Squires, which says, so in a nutshell, I'm just going to tell you, so you still cannot name your AI computer as an inventor in the US Patent Office. That's fine. But the AI can assist a human inventor, and you can still name the human inventor. The old guidelines actually required the human to have a significant contribution to the conception of the invention. And now the new guidelines just say that the inventor just has to have a contribution to the conception. So in other words, we're not changing the original test from the last 200 years. Just if you have contributed to an invention, you are named as an inventor. You still can't name a computer as an inventor, but that's fine. But at least someone is named as an inventor if they've done things. So an AI system is an analogous to lab equipment, your software tools, etc. And you can use those. And it's as if they were like your co-inventor. It's just you can't name them, which is, again, good news for all. Last one. Okay. So if someone has a software patent, you can actually try to invalidate them in the patent office. Something called an IPR, or inter partes review. And often these are used against software patents. So very recently, again, the commissioner has used this thing called a discretionary denial, which means he can use his discretion to just deny the appeal. In other words, if someone is trying to invalidate a software patent, the commissioner stepped in and just decided that he would use his discretion without reasoning to deny anyone trying to invalidate these particular software patents. And he did 13 of them and didn't give any reasoning. He just said, I have discretion under my legal power. I will now use that discretion to not even hear other people trying to invalidate these software patents for the same reasons we talked about, being an abstract idea, mere tool, mere algorithm. So that's why this is, again, good news for software patents, because even if someone, and it's cheaper to fight a software patent in the patent office than at court, and it's more predictable because at court they're assessing both the validity of the patent and whether you infringe. Whereas if you're fighting at the patent office for these IPRs, you are not, they don't address infringement at all. They're only addressing invalidity, which means, you're no worse off. You're just trying to invalidate someone else's patent. Anyways, the director has denied all of these, not all of them, but many invalidity proceedings using his own discretion. So whether this is political or legal or whatever, it doesn't matter. The point is the director is doing it. And I believe one of them has survived some sort of review at the court. Don't hold me to that. But the court just said, yeah, he has discretion, so we're not going to hear it, and it's within the rule of law, which is very odd. Okay, there's some takeaways that I provided here. I don't think they're that. It's hard to. You would just try to do best practices, as like we talked about. There's just have lots of claims of different scope, broad and narrow, because you never know what's going to hit. Like, I don't totally agree that a broader claim should be more patentable than a narrower one, so I wouldn't hold anything to anything other than just put it all in. So that's my conclusion. We have all these decisions and materials linked, and Dave will upload them to the portal. Or I think it's on the website already.
Yeah, it's actually
Any
up there.
questions? Okay, good. Can I take questions, or?
Yeah, we'll take questions at the end.
Okay.
So keep your questions. Thank you, Ben.